a week ago Saturday, right?
Yes. It was
Okay, Saturday in the
morning.
morning?
Yes, sir.
We all appeared on a conference call?
Yes, sir.
Okay. And you were under oath at that time?
I was.
All right, counsel, page 53, lines 10 through 16. Let me just ask you to review that highlighted portion and see if that refreshes your memory as to what your understanding was as to where Trayvon Martin was specifically straddled on the defendant.
Yes, sir.
Okay. Where was it?
In the area of his belly button.
Very good.
Not directly on it.
Well, by area of belly button, you mean here?
No, I object that he needs to read the entire question.
You can do that on your redirect.
And, okay.
By area of belly button, do you mean here?
If that's where your navel is, yes, sir. The area is, it's either going to be below that, it's going to be in the area. I wasn't trying to say that it's on his belly button.
Okay. You recognize this as being a human-type figure, right?
Yes, sir.
Okay. It's actually got a belly button, right?
It surely does.
Does it appear to be anatomically correct?
For the belly button, yes, sir.
All right. So, as the defendant described it to you, is this the way he described it, in the area of his belly button?
Well, what's really important right now, sir, number one, you've got your knees up pretty high in his waist. If you want to slide down just a little bit more so that you're in the, there you go. Have a squat. I can't see your crotch, but in the area of his belly button, yes,
Okay,
sir.
well, here's his belly button. Am I in the area?
Yes, sir.
Okay. By the way, did you have the defendant do this?
No, sir.
When you talked to him, you didn't have him do that?
No, sir.
Okay. If this person, this mannequin, were carrying a firearm on their waist, where would the gun be right now in relation to me?
Would be at your left inner thigh.
Right here, right?
Yes. If he was right-handed, it would be at your left inner thigh. Yes, sir.
Right. Underneath my leg.
Yes, inside your leg.
Okay. Were you aware that the defendant described to his best friend that when he slid down, the defendant slid down, that Trayvon Martin was up around his armpits? Were you aware of that?
No, I've not heard that. No, sir.
Okay. Well, where would the gun be now?
Now the gun would be behind your left leg.
Okay. The defendant did tell you, though, as well, that at some point he slid down further between Trayvon Martin's legs.
Yes, he did indicate that he was sliding down, and I believe that's how the jacket came up, exposing the firearm.
You know, if I can have just a moment. You didn't ask the defendant how he was able to get his firearm, did you?
No, sir. He explained that he reached down and grabbed it.
But he also explained that Trayvon Martin was in the area of his belly button, right?
Yes, at one point.
Right.
The whole thing's fluid, so it's not like Trayvon
Right.
just got in one spot. He moved all around, and
He
it
said
didn't
at
move.
first he was in the area of his belly button, and then he actually slid down. That happened after, right?
Yes.
And then he said that's when he grabbed his gun.
Yes, after he had slid down, the jacket came up. You're implying that Trayvon didn't move so that it wouldn't be accessible, but we have to remember in a dynamic event, it's not just one person doing all the movements, so we have to take into account both sides of the equation as it's interacting.
Well, did the defendant tell you that Trayvon Martin slid down? He didn't do that, did he?
No, sir.
You were asked if you reviewed the medical examiner's report.
Yes, sir.
You did?
Yes, sir.
Do you remember the trajectory of the bullet being referenced in there at being at 90 degrees?
Yes, sir, and I believe front to back.
Right. Wouldn't that be consistent with Trayvon Martin getting off of George Zimmerman and George Zimmerman raising the gun and firing it?
Well, when you talk about angles of anything, sir, it could be consistent with any kind of movement. We could say it could happen that way, it could happen another way. There are various ways that you could have it happen, and you know, you weren't there, I wasn't there, so the information that we have is what
On the
Mr.
defendant, right?
That's correct, sir.
Right. Okay. Judge Mount, first witness again.
Yes, you may.
I mean, your information came from the defendant.
Not all of it, sir. Your
Well-
indication is that the only person I spoke with is the defendant, and that's not accurate.
I'm talking at the time the shot was fired.
The time the shot was fired, the information that I culminated on opinion on that is a culmination of everything. The only person that could provide any insight into at that very second that was there was Mr. Zimmerman.
Okay. And he said he was in the waist area, and then the defendant may have, or Trayvon Martin may have slid down. And my question to you is, would it be consistent, the 90 degrees, if Trayvon Martin had been backing up and the defendant raised his gun and shot at 90 degrees?
With you at that angle, 90 degrees to what, sir? When you talk about 90 degrees, we're talking about
Right.
this degree.
Right.
So if it's front to back 90 degrees and you're standing there and you're holding the gun up, already you're at least 45 degrees where you are because he's laying flat on the ground.
Right, but if
and you're
Trayvon
standing
Martin,
straight up.
if Trayvon,
One at a time and slow down just a little.
I apologize. If Trayvon Martin's backing up, could not the defendant have shot him at a 90-degree angle?
If Trayvon Martin is backing up
Correct.
and you're saying that Mr. Zimmerman is laying on his back and he brings the gun to bear on Trayvon, if he's backing up, then now that suddenly that bullet's going to go straight in, back, front to back.
I'm
at a
asking you,
90
could
degree
he shoot him at a 90-degree angle?
I think I'm getting really lost in this 90-degree thing is really, I don't want to misinform the jury with my answer.
Okay. Well, 90 degrees was what you read in the medical examiner's report,
That's
right?
correct. And my interpretation was 90 degrees front to back was like it was a, for lack of a better word, I'm not a medical examiner, but my interpretation of the information provided was that it would give it a front to back, for lack of layman's terms, like a level entry,
Right.
not an angled entry.
Correct.
So as this event is transitioning and you're coming back, if this comes back, then we maintain that.
Right.
If it's a struggle that's forward, so in your 90-degree reference, I want to be very clear that I'm not trying to say that the manner in which you're demonstrating visually right there, with him raising his gun up, with you sitting back, I don't know how you could get a 90-degree entry if you're sitting straight back like this.
Well, I'm not sitting straight back. I'm just,
From my perspective is all I'm trying to say, sir, is
Okay.
it looks like you're more vertically upright and he's sort of like the two of you form a 90.
Right.
And if the two of you form a 90 where you're straight up and he brings the gun to bear just based on the dynamics of his arm, there wouldn't be a way for it to go straight in. There has to be mutual movement to keep them within
right.
line.
As in, if the defendant started to sit up and Trayvon Martin was getting up, are you saying that there couldn't be a 90-degree angle?
Am I saying there couldn't be a
Right.
90-degree angle with
Right.
him in a half-up position
Right.
and you trying to get up? If the bodies become in line, it's as long, in order, from my understanding, to maintain the entry, we're going to have to maintain some relativity between the two persons, right? So the relativity, I can sit here and say the same thing, that if I'm laying completely back and you're more forward, I can get a 90-degree entry. If we're both coming up, you're asking me to bring up a conclusion, could it happen that way? The answer is absolutely yes. If he's getting up and he's getting up together, sure. There's no way I can sit here and say that, no, you couldn't have two people that are maintaining alignment not have that entry.
And you were also provided the firearms report, right? And you learned that it was a contact wound with the clothing that Trayvon Martin had on?
Yes, sir, the clothing.
But it wasn't a contact wound with his chest.
Correct.
So that would be consistent with Trayvon Martin leaning over when he got shot.
Yes,
Right.
sir, sure.
Okay. You were asked, or you actually spoke a little bit about the lighting, right?
Yes, sir.
Did you, you actually went to the scene for the purpose of getting idea of the lighting, right?
Yes, sir.
But you didn't get an idea of the lighting, did you?
No, I've failed to take into account the change in season. So when I got there, it was still daylight or dusk area.
And when was that?
Off the top of my head, I can't remember the exact date, sir. I think I might have told you in deposition, but I don't remember exactly off the
Could you
top of my head.
ballpark it? Was it in July?
July, no.
Was it in June?
Maybe early June. I don't remember the exact date in which I attempted that.
So you went to the scene to try to get an idea of the lighting, and
Yes,
the sun
sir.
had not gone down.
Correct. It was not completely set.
Right. So you didn't wait until it had set,
No, sir.
and you didn't go back
No.
when it was dark some other day.
No.
The defendant told you that Trayvon Martin reached across his body to try to get the gun,
He mentioned that, yes, sir.
but he never told you that Trayvon Martin actually touched the gun.
I don't believe he said he actually touched the gun. He felt him moving toward the gun. He perceived that he was moving toward the gun.
Were you aware that the defendant told his best friend that Trayvon Martin actually touched the gun, grabbed it?
It's possible he said that.
I mean, you don't...
I don't think it would affect, whether you're reaching for it or grabbing it.
I'm just
Six
asking
one half
you.
of that's in the other.
Mark Osterman, does that name sound familiar?
Yes, sir.
Did you review his testimony? Or his statements, pretrial statements?
I reviewed his statements, but I focused in on the people that actually had witness accounts. Again, my job as an expert is to look at the event, not hearsay that comes from somebody else that they're saying, because number one, dealing with man to man, I have always got a concern that I haven't met too many men whose egos don't enter into it when they're having a conversation with somebody. It's usually generally women that can keep their composure and not feel like they're, have to say something that makes another guy feel better about them. But the statements I focused in on were the events that took place there, not 110% what somebody else said they heard somebody say.
But part of your focus, a good part of your focus was the only witness who could tell you from start to finish, and that was the defendant, right?
No, the totality of the event. Again, you're trying to narrow it down, and it's interesting because we could narrow it down to any specific part that you'd like, not just the one part that seems to be advantageous. When we look at the totality of the event, I reviewed everything from everybody that can provide information about the event itself. It is true, the only person currently that we can gain information from that specifically can address the event that unfolded away from the calls and away from the one person is Mr. Zimmerman. Not Mr. Osterman or anybody else, just Mr. Zimmerman.
Was your conversation with the defendant important?
Of course it's important, sir.
So wouldn't his statements to someone else about the exact same event also be important?
Sir, I've listened to the statements related by other people, and it always comes back down to the fishing story. That even though somebody may want to be supportive, the human element, the human mind, likes to fill in the blanks. It's a natural human thing that we see something, and if we don't understand it, the creative side of our brains will help us fill it in. They will find a way. And that is another reason why if you wait too long and you allow people to get too many interactions with other people, the statements can change because now they have outside influences. As far as what he said to somebody else bringing in is adding more importance to me at that point, that would be inaccurate because the information I need is about that night, not somebody else's interpretation about what somebody else said.
And you talked about the use of force continuum, right?
Yes, sir.
And explain that for the jury what that is.
Like I said, it's a force continuum. It's a systematic approach to escalation and de-escalation of force, taking into consideration background training experience, weapons availability, and the totality of an event. It's basically saying that if X happens, you can respond with Y. It's
right.
The idea is to give an objectively reasonable connection between two behaviors.
And if Trayvon Martin was backing up, as I demonstrated a moment ago, that would be a de-escalation of force, right?
Sure. If a person is disengaging, it would be a de-escalation.
Right.
As long as they're not disengaging to go to another weapon, but
right.
Just in general terms, like you mentioned, a backing away. If I was giving up, that's a de-escalation.
You also mentioned in the force continuum there are options, right?
Yes, sir.
Okay. And you would agree with me that someone in the defendant's position had other options?
I would disagree with you, sir. You're telling me that somebody in the defendant's position, the moment that perception became a deadly force encounter, the only option that's justifiable would be the actual application of that level of force. I mean, we can sit here all day long and come up with 1,000 things that may have been able to be done, but the reality comes back to what a person is perceiving to be their reality and what the approved responses are for that given reality.
Okay, but you don't know what was in his head, do you?
Based solely on the information that I reviewed, based on what I heard from the 911 calls, based on the inclusion of the physical evidence of the injuries to his face and the back of his head, and the fact that, in my opinion, most of that information meshes together. So I can draw my opinion and I can come to the conclusion of what I believe the perception to be. And based on that perception, I know what a generalized outcome could or should be.
All right, when you said 911 call, you talking about the one with the screams on it?
Yes, sir.
Okay, you're not telling this jury that George Zimmerman's the one screaming, are you?
I'm not telling the jury anything other than what I just told you. If you take into consideration the 911 call, you mentioned whether it was him or not. I wasn't there, I couldn't tell you that. I can tell you that based on Mr. Good's statements, that he believed that the screams for help were coming from the gentleman on the bottom, otherwise he would have heard an echoing sound because it wasn't facing away from him. And if you take that concept and you include it in, then it would fall into play that those screams were Mr. Zimmerman. But in the same token, if you're on top trying to hold somebody down to disengage, as you've indicated, I'm trying to get away from him, and somebody now is coming out saying, hey, stop, and there's no indication from you as the person on top trying to hold somebody back that you need help, and that your inference is that those screams were his help, why was there no acknowledgement of the person behind him? So again, any one of these things in and of themselves don't tell the whole story. It's about taking all of the information and considering all of the components and coming to a conclusion.
Well, let me ask you this. In your experience, if Trayvon Martin or anyone would have been in that situation and would have been aware of the defendant's gun, either seen it or felt it, would you expect them to scream for help?
You're asking me if somebody saw, if I am beating the crud out of you and I suddenly know you have a gun, would I expect me to be screaming for help?
Would that be unusual for a person who saw a gun too?
You just said if I was Trayvon Martin in that situation and we take it to the place that we've gone with the physical evidence where I'm the aggressor, I'm on you and suddenly I see you have a gun, my first instinct as the aggressor is not going to be to scream for help. My first instinct as the aggressor, if I'm the one that's being the aggressor, is to go for the weapon that's going to help me continue my aggression, not prevent it from being implemented to stop me.
Okay, my question was, it would be unusual for a person who saw someone that they were in combat with a firearm, would it be unusual for that person to yell for help, in your experience?
I want to make sure I'm clear because you just said, would it be unusual for a person involved in a combat situation to suddenly see a gun and scream for help? Is that the question that you... I want to make sure I'm very clear on it because I don't want to misinterpret this because I want to be careful on what I say with what you're asking.
I'm trying to make it more simple. I mean, if a person sees a firearm, would it be unusual for them to yell for help?
If an average individual saw a gun and it was pointed at them, I would say absolutely not. Anybody looking down the barrel of a firearm, if you're able to vocalize something, would probably yell for help. I mean, if you're looking down the barrel of a gun, I would hope if you're looking down the barrel of a gun, you'd be in fear for your life.
All right, back to the options. We kind of got away from that. There are other options that George Zimmerman could have used to get out of that situation, right?
Based on my understanding of his physical skills and things, he wasn't physically trained. Asking of options, we go back to what we talk about for subject factors, variables involved in an individual in the event. What's your background training and experience? One of the training instructor certifications I have is in one-on-one control tactics, and that is a ground fighting discipline. So yes, there's a lot of options that are available, but if I have no background training or experience to lead me down those paths, there's nothing else. So I am very limited on options. There are always options in every force event. It's just a matter of what you as an individual see as being your options.
All right, but the defendant didn't use any other options, did he, other than pulling out the gun?
Well, I mean, if we go down the path where he was the one vocalizing, he did scream for help. He elicited assistance from other people. There were other options. He obviously continued to try to resist. He was doing, as you know, I guess they refer to as the shrimping technique, trying to get and move around. As far as drawing a conclusion, I don't know what else he could have done based on his abilities, because, not to be offensive to Mr. Zimmerman, but he doesn't seem to have any.
You're not suggesting that the defendant was just laying there getting hit, right?
Absolutely not. No,
he would
sir.
have been defending himself.
I would presume that at a minimum he would be struggling in some form or fashion to create some kind of gap or distance. Instinctually, that seems like it would just be a normal thing.
Did you say that there's a verbal component to the use of force?
Absolutely.
Like telling someone who you are?
Well, the verbal component is anytime you interact with people, you can escalate or de-escalate an issue based on communication. If the levels that when we speak about law enforcement, you have presence, and they offer different levels of resistance. For us, it would be, you tell them, stand over here. No, I'm not doing that. Well, that's verbal resistance. That's a verbal communication. The officer's response can be verbal, which would be, you're under arrest, come stand over here, blah, blah, blah. In the individual or civilian realm, verbalization can be screaming for help. It can be telling the person, no, stop, don't, whatever those cases might be. That's the verbal component.
And it also could be like telling them who you are. Like, I'm a resident here. I'm a neighborhood watch person.
Absolutely. You could tell them that I'm Dennis Root and I'm here to say hello.
And you could tell them what your purpose is, right? Like, I'm a neighborhood watch person and I'd like to know what you're doing.
Yes, yeah. If you afford the ability to communicate with somebody, it's always a good idea to introduce yourself and advise them.
I mean, you would do that before using force, right?
Well, sir, again, you're asking me what I would do, and I can tell you this. There's a lot of things that if I was in that same situation, I most certainly would have done differently. But the reality still comes down to when you say that somebody that's based on, again, going off 911 calls, this gap, whatever it happens to be, he's in an environment, he's doing the golden rule of community-oriented type programs is if you see something, say something. That's the whole idea. And Mr. Zimmerman has a history of that. He reported, by the calls, everything. He's had numerous calls from a variety of reasons, from children to suspicious persons. The interaction component, is he responsible for when you walk up to somebody and if they're in a suspicious area, hey, I'm a crime watch person, if you have the distance and ability and that comes to mind, that's fine. But that also takes training and thought on the forefront. However, on the other side of that coin, if I'm suddenly surprised by something, communication may not be the first thing that comes to my mind, especially if it's a blind side of some type.
You did talk to Adam Pollack, right?
I did, sir.
And you actually talked to the defendant about some of those classes, right?
Yes, sir.
But you didn't ask the defendant how long he had been taking those classes?
No, sir.
And you would agree with me that should have been asked?
No, sir.
Did you not say that not getting that information was a failure on your part?
Yes, and as I would say anything, just like I did about asking the other thing, anything I don't ask, I always take on as my responsibility. It doesn't change the outcome of an event. It doesn't change the total influence. The fact remains that if he had been spending 3 years and was just barely able to get into a grappling ring with somebody where he can say uncle, and he spent 3 years boxing and he can't even get a ring with another person, it really is a moot point about how long he's been doing it. The end result is I got the information from the source that actually can give me a neutral opinion because he was the one doing the training.
Because the defendant's not neutral?
Sir, just like we said, and you said it yourself, you have to take it with a grain of salt. The only way that I can come up to a neutral opinion on anything is by giving minimal weight to Mr. Zimmerman and trying to find the information from some other source. Unfortunately, depending on the variable that we're asking, the only source may be Mr. Zimmerman, but sources that I can get information from somewhere else other than the defendant, I would seek that because that gives me more possibility of getting the truth rather than what some quote-unquote defendant wants me to hear.
All right, so you didn't ask him for how long he had been taking the classes, like over a year. You didn't ask him.
No, sir.
You didn't ask him how long each class was, like 2 hours.
Generally speaking, when you look at any of the combative sports, you're looking at an hour and a half to 2 hours because of warm-up, stretching, the actual activities, cool down, and stretching again. So I probably didn't ask that only because the general guidance on that for just physical technique type classes, that seems to be the norm.
And you talked a little bit about Trayvon Martin. You wanted to know about his physical ability, right?
I would love to have known totally about it, yes, sir.
But you said, yeah, I believe your words were he was physically active.
That was my understanding, yes, sir.
Because you had information that in middle school he played football.
Again, and I believe I even said it, before this case began, there was information in the media.
Your Honor, can we approach for a moment?
Yes.
Sir, I believe you testified on direct that you were told that he played football in middle school. Is that right?
Yes, yes, sir.
And you had his height and weight, correct?
Yes, sir.
5'11" and 158 pounds.
Yes, sir.
You got that from the autopsy report?
Yes, sir.
Judge, if I can have just a moment.
Yes, you may.
You were asked questions about basic certifications for various weapons, right?
Yes, sir.
And you're aware that the defendant had a concealed weapons permit?
Yes, sir.
So he would have taken a course for that?
Yes, sir.
Isn't a person who is licensed to carry a concealed firearm supposed to disclose that to the police when they talk to him?
There's no law about it.
Aren't they advised to do that? When you speak to law enforcement, you advise them that you're armed?
You mean in person?
I mean over the phone, in person at all?
Not over the phone. Whenever you interact with a police officer, if you're carrying a concealed weapon, obviously, traffic stop, interaction on the street, something to that effect, we tell everyone that when you interact with law enforcement, the first thing you want to do is make sure your hands are clearly visible and just let them know that you have a concealed weapons permit and you are carrying a firearm. We don't really ever address something over the phone. I mean, sure, I guess it would be nice, but we don't address it.
Well, to be clear, the defendant did not advise the dispatcher that he was carrying a firearm.
No.
And you said that you have a criminal justice degree, correct?
Yes, sir.
Were you taught the law of self-defense in any of those courses?
I've taught a lot of laws, yes, sir. I'm sure we covered that.
Were you taught fact scenarios that constituted self-defense?
I can't say that we were caught fact scenarios. Every instructor that's responsible for relating information relates it differently in every class. I can't speak to how everybody does it. I know how I relate the information, but I can't speak to how everybody else does.
And it was your opinion that a weapon was not used on the defendant?
I didn't see, are you talking about Mr. Zimmerman? There was no weapon used on Mr. Zimmerman by
Yeah,
Mr. Martin?
I believe that's what you said.
Yes, I didn't see any indication that a weapon of any type was used on him.
You did see an indication that a weapon was used on Trayvon Martin.
Did I see?
Did you see an indication that a weapon was
Of course,
used on
he
Trayvon Martin?
was shot, yes, sir.
Your Honor, have just a moment.
Yes, you may.
All right. Mr. Root, in listening to the non-emergency call and your conversation with the defendant, he told you he was following Trayvon Martin.
I think the term that he used was trailing, which to me, it means following. I mean,
Well,
it's the same thing.
Okay. I mean, do you remember when Sean Nofke, the dispatcher, asked him, are you following him? And the defendant said,
Oh, yes, sir. Absolutely. In the 911 call, absolutely. He asked him, are you following him? He said, we don't need you to do that.
Did you read the defendant's written statement?
I'm sure I would have.
It
I
was
can't
about
recall.
4 pages handwritten.
I am confident I did. I just don't recall exactly what he had written. I mean, if you ask me a question about it, if I don't know, I'll honestly tell you.
Okay.
I've read so many of the documents, it's...
I understand. Do you recall the term that the defendant used to refer to Trayvon Martin in that written statement?
No, that I honestly, I don't recall the term that...
You don't recall the term suspect?
Okay. I don't directly recall it, but I would take your word that he wrote suspect there.
All right. You would agree with me that that's a police term, right?
Oh, sure. It's
That's
a
the way
term
you
that it's also a crime prevention term also. It's anybody that you interact with, they utilize the same verbiage, even though you may not get it. Most certainly, it's like saying civilian, and I get yelled at by a friend of mine because it's individual. But in law enforcement term, every individual is a civilian. So for suspect, we refer to as being the other person, the bad guy.
All right. Judge, that's all I have. Thank you.
Yes, Your Honor. So I'm clear, would you consider a big old piece of concrete a weapon if I hit you on the head with it?
If you hit me in the head with concrete, yes, I would.
How about if I
consider
just
that.
took your head and smashed it onto concrete? May I use your doll for a moment? Of course. Let's just use this for a moment because I want to follow up on some of Mr. Guy's questions. So, George Zimmerman, Trayvon Martin. Were the injuries on Mr. Zimmerman's back of his head consistent with someone doing this on cement?
I don't think so.
How about this? How about somebody resisting the attempt? The injuries, the 2 lacerations, could that have come from cement? If somebody was resisting me pushing down like this?
I believe so. I believe it was a culmination of downward force, whether it was from pushing or striking, and I know clearly by the injuries to his face, and that would drive him back, his head striking hard into the concrete.
Would you expect, based upon your training and experience, that somebody getting their head struck on the cement would attempt to resist it happening?
Of course, they would. Normal human instinct would try to move away from the pain stimulus, which would just create another gap to be driven back.
And would that occur not only the first time, but every subsequent time?
Whether it's a push or a strike, every time you drive a strike or push straight downward, the body goes until it hits an object that'll stop it.
Did you see the pictures of the injuries that showed punctate bruising and lacerations on the side of Mrs. Zimmerman's head?
Those were when I said blows raining down earlier, those were the things that really caught my eye, that supported the fact that it was a striking and not a pushing so much, because of all of the, lack of a better word, injury or damage that I saw on the side of the head. There's swelling all around his head. It's not just the facial area, it's all around the front
Were
of
those
the portion of his
injuries
head.
consistent with somebody pushing your head down to the side You see me move it to the side like that. Is that similar to that, hitting cement?
It could be. It could be that, or it could be punches as well, driving those strikes in.
And then on the other side, would the injuries consist in hitting it down on the side, on the left side of Mr. Zimmerman?
It could be, and you know, and just like Mr. Guy pointed out, if Mr. Zimmerman is on the bottom and he's not just laying there, he is moving, whether he's trying to defend himself, trying to do his sliding techniques or whatever they are, as he's turning his body or his head in those efforts, it's going to redirect and realign, so whatever push or punch comes in next, if he's turned this way, it's going to be a strike to a side, the front. That's all indicative of an ongoing combat event.
Now, talking about the angle, Mr. Guy, I think, was suggesting that we need to stay focused with the angle of entry of the wound being basically 90 degrees, so it's straight in, correct?
That's what he said, yes.
Now, that could happen, of course, as Mr. Guy suggested, maybe something like this, if Mrs. Trayvon Martin is trying to now back away at the end of the 45 seconds of screaming, correct?
Correct.
Do you agree that that's a possibility?
Absolutely, it's a possibility.
Do you have any evidence that beyond a reasonable doubt that is what happened?
No.
Could it happen this way?
Yes.
Same angle. Could it happen
Yes.
this way?
Yes.
Could it happen if Mr. Martin is reaching back with his hand for yet the final strike or something like that? Could it happen right there when he's coming back over?
As long as the alignments of the body stay within those same relative positions, where they are within that axis of movement, it's a possibility.
Now, you know that Mr. Zimmerman was, in fact, able to get his gun out of the right side hip, correct?
Yes.
Now, somehow he got to that, correct?
Correct.
How much weight do you give to Mr. Zimmerman's ability to disclose and to advise exactly how that happened?
Not a lot.
Why not?
Because when he became aware of the presence of the firearm, he reached for it. The
Mr.
transition under stress, the transition of how it got into the hand is kind of moot. And, you know, my background, training, and experience, I've interviewed numerous police officers involved in shootings. And frequently I hear, I shot, well, when you draw, they're not clear on how they got into position. They just know they did it. Instinctually, survival mechanism, whatever it is, the point still remains, the gun was in his hand and he did in fact discharge it.
And he discharged it in a way that was in contact with billowing clothing that was 2 to 4 inches away from his chest, correct?
Correct, which, you know, when we think about the movements, if he's moving with I think it was an Arizona iced tea in his jacket, the hoodie, transitioning, leaning forward, if that body position's there, that tea is going to keep it away as they transition back. If he's at some point leaning too far back or whatever, trying to get up, that tea is going to be pushing the shirt the opposite direction because it's going with the motion too. At what point and where they were, I can't specifically say.
Okay. In the context of your training experiences, the way combat events and how they occur, is it possible that at some point Mr. Martin was in fact up here?
There's no question that it's possible because during the event, when he says he's sliding down, I don't expect Mr. Martin to be able to match him move for move. Is it possible that at some point he was up on his chest? Yes.
Okay.
Then he slides back.
And is it possible that at some point he was here?
Sure.
And how about, is it possible that at some point during that dynamic altercation he was even this far down?
It's possible.
When he's this far down, just over the thighs, where is that hip holster? I'm not going to ask you to get up. Just tell me when to stop my finger as to where the hip holster is.
Stop.
Right here.
Yes, sir. Right at the hip
Available to
line.
Mr. Zimmerman at that point.
Yes, sir.
Is it available to him at this point?
Yes, sir.
How about up here?
Yes, sir.
At this point, where you say it's available, what is my tie pointing down towards? Can you
His
see
belly
that?
button.
My tie is pointing directly to the belly button?
Yes, sir.
Based upon your training experience, was there just, how much thrashing or movement was happening in that dynamic event between these two men at that point?
I would have to say a lot.
Was that evidenced by the contusions and abrasions on Mrs. Zimmerman's head?
Yes, sir. In the clothing, showing the contact, the wet spots on the clothing. You know, I think that you're not going to be involved in an encounter like this without it being dynamic.
Speaking of weapons that are available, we had talked about mass approach the witness for a moment. Do you consider that this could be a weapon?
Yes, sir.
Could be a weapon?
Yes, sir.
Could be a weapon?
Yes, sir.
Most anything that you want to be a weapon could be a weapon, correct?
Yes, sir. I do training classes on improvised weapon systems. Anything can be utilized. Depends on how it's used.
You certainly agree that fists can be weapons, right?
Most definitely.
And you saw evidence of injuries caused by the weapon of a fist, right?
Yes.
And the weapon of concrete?
Yes, his head striking the concrete, yes.
And just so we're clear, did you see any evidence of any injury on Trayvon Martin from your review of the autopsy that was consistent with him being hit by this?
I didn't see anything to that effect, no, sir.
Did you see any evidence of any injuries of Trayvon Martin being hit by anything?
I didn't note any injuries on Trayvon Martin, except for there was the one point on his hand.
How do you explain that fact to this jury? How do you explain the fact that in an ongoing altercation, I'm going to presume for the point of this conversation that it was Mr. Zimmerman screaming, just for this.
Yes, sir.
And it was Mr. Zimmerman screaming for 40 seconds. How do you explain to this jury that he couldn't even land a strike in defense of himself?
Well, if you...
Does that object to that call for speculation?
Your Honor, I would ask.
You're asking for an explanation?
I am, and the door has, I think, been open as to potentialities that would happen between the two that night by Mr. Guy.
I'll overrule.
Can you restate the question again? I'm sorry.
Sure. Can you explain to the jury a couple of facts? I'm going to suggest that it was Mrs. Zimmerman screaming, and you've now testified that Mrs. Zimmerman was not able to strike nary a blow on Mr. Martin. Can you explain to the jury how that might have happened, how that occurred?
Well, if we were saying that he's the individual screaming, then we could conclude that with Mr. Martin on top of him, Mr. Martin was the aggressor, the strikes were being rained down, and he, for lack of better words, was physically incapable of responding, screaming for help, wanting somebody else to help him out of a very bad situation. And it's possible that his hands were busy. They were, maybe they were pushing. I wasn't there, so I can't say exactly what his hands were doing. But I know that if you're the aggressor in a fight, how can you be the aggressor and not hurt somebody? So in this situation, if he's the one screaming, the reason that there's an absence of injuries is because he wasn't the one throwing strikes.
Is it unusual for someone to simply be completely dominated by another one who is physically better abilitied?
It all goes back to mindset. And it's not unusual, but what really, in listening to the non-emergency call that Mr. Zimmerman made, then it's clear during his conversation that he becomes concerned about Mr. Martin, especially when he's looking at him and walking back toward him, because he even vocalizes this to the dispatcher. He didn't get out of the car at that point to confront him. To me, my perspective is because Mr. Martin is not the I'm-in-your-face confrontational person. When he had the opportunity where he mentioned that Mr. Martin had taken off running, or I'm sorry, Mr. Zimmerman's not confrontational. When Mr. Martin had taken off, and he announces that he took off running, if that's when he gets out and he, is following, and the operator asks, "Are you following me?" He says, "Yes, I am." It's because there's no threat. He took off running. Everything about that one call that leads up indicates that he had concern about his safety. I can hear it in his voice. Then when he interacts with him and he's coming back and he's face-to-face with somebody, he's not confrontational. He's looking at me. He starts talking about and you can hear it in the voice that he's talking to the dispatcher. And then when Mr. Martin's leaving again, suddenly his vernaculars strengthen, and he struck me as the type of person that doesn't have a problem telling you that somebody's a jerk, but he doesn't want to tell them that. So I actually lost the question. I'm sorry.
That's okay.
I apologize. I know I was going somewhere. I just don't remember where it was.
I was just going to let you go, but we'll
Thanks.
refocus it. Let's start where I was going to.
Let me ask you a question. We have plans for the jury to go out for lunch, and it's going to take an extra long lunch time. Is this a good breaking point?
It is, Your Honor. Thank you.
Thank you. Ladies and gentlemen, as you're packing up your stuff, I'm going to remind you that you're not to discuss the case amongst yourselves or with anybody else. You're not to read or listen to any radio, television, or newspaper reports about the case. You're not to use any type of an electronic device to get on the internet to do an independent research about the case, people, places, things, or terminology. And finally, you're not to read or create any tweets, emails, text messages, or social networking pages about the case. I have your assurance that you'll abide by these instructions? Yes. Okay, with that, put your notepads down, follow Deputy Jarvis, enjoy your lunch. We'll be back at 1:45. Please be seated. Mr. Root, during the lunch hour, you're free to go about your own business, but you are not free to talk to anybody about your testimony. That includes the lawyers, okay? We'll see you back at 1:45. Is there anything we need to take up before we recess for lunch?
No, Your Honor, there are a few things that we have stipulations for entry, but I can do that at any point during my case.
Okay.
Maybe when we get back or afterwards.
That will work. Thank you. Court is in recess.